Would you willingly sign a formal legal paper today, knowing it legally permits an administrative system to freeze your family assets tomorrow? Most hardworking professionals believe a standardized, traditional document guarantees a flawless, protected transfer of wealth directly to their children. This deep psychological cognitive bias of false security leads families to assume their hard-earned property will instantly bypass external institutional friction. The hidden structural reality is that this exact document acts as a mandatory ticket into a highly inefficient public probate court administration. Instead of securing your generational legacy, it initiates months of systemic asset erosion, locking liquidity while your heirs wait in legal limbo. Before a single dollar reaches your children, the system systematically diverts a substantial percentage of your gross estate to third-party institutions. But what if a subtle legal alternative exists that completely immunizes your capital from this administrative clearinghouse without changing your lifestyle? To understand why your net worth faces this structural vulnerability, we must dissect the economic metrics governing traditional wealth transfers. Think of the traditional framework not as an open door, but as a mandatory structural bottleneck where every asset is audited. Every house, bank account, and business ledger must stand before this public counter, enduring a mandatory 5% to 10% systemic leakage. These legal costs are calculated based on the gross value of your property, entirely ignoring how much debt remains outstanding. If you pass away owning a home worth $500,000, the statutory fees are levied against that full amount, not your equity. Even if your remaining mortgage is $400,000, the administrative system computes its collection as if you owned the property outright. This operational setup ensures that middle-class families bear the highest relative financial burden, suffering massive wealth transfer friction unnecessarily. Furthermore, because this process takes place within a public clearinghouse, your entire family financial sheet becomes a matter of public record. Predatory solicitors and aggressive creditors routinely exploit these public filings, targeting grieving heirs when they are most psychologically vulnerable. While high-net-worth individuals deploy advanced insulation strategies, standard wage earners allow their wealth preservation velocity to drop precipitously. The tragedy is that this systemic asymmetry is completely voluntary, yet millions remain trapped by the illusion of traditional protection. By understanding the precise legal mechanics, you can implement an automated environmental default switch that completely bypasses this institutional interference. Upgrade your financial intelligence network. Subscribe to Economecha now to bypass capitalistic blind spots and structurally immunize your hard-earned assets. To fully comprehend the structural divergence in asset preservation velocity, let us analyze two identical $1 million middle-class family estates. Estate A relies entirely on a traditional last will and testament, assuming their generational wealth transfer will be frictionless. Conversely, Estate B utilizes modern living trust mechanics, proactively structuring their holdings to maintain maximum capital liquidity from day one. As both estates cross the generational threshold over a 12-month timeline, the structural differences create a massive wealth gap. Estate A immediately enters the public court administration system, triggering a mandatory 9-month asset freeze and $60,000 in statutory legal erosion. As both $1 million accounts move through the 12-month calendar, the operational divergence creates an irreversible financial separation between the families. Estate A immediately encounters massive wealth transfer friction, watching its liquid capital get heavily restricted by administrative protocols. Meanwhile, Estate B bypasses the traditional bottleneck completely, maintaining an optimized asset preservation velocity that keeps every single dollar active. For 9 months straight, the heirs of Estate A cannot access a single property or bank account due to ongoing audits. Conversely, the modern living trust mechanics of Estate B execute an instantaneous private transfer, placing funds directly into the heir's hands. By the time the public administration concludes, Estate A suffers a mandatory $60,000 loss, entirely dedicated to statutory processing fees. Estate B experiences exactly zero statutory leakage, achieving a 100% frictionless transfer that keeps the entire $1 million family nest egg intact. Because Estate A relied on a traditional will, every detail of their debt, assets, and distribution becomes searchable public data. Estate B operates entirely within a private legal framework, ensuring that outside corporate entities and predatory solicitors never see family accounts. This stark economic contrast proves that the legal mechanism you choose dictates whether your children inherit wealth or an administrative nightmare. That missing $60,000 could have been invested in growth ETFs, compounding into hundreds of thousands over the next few decades. Beyond the pure financial capital drain, the administrative friction subjects grieving family members to intense emotional toll and bureaucratic fatigue. Meanwhile, the heirs of Estate B focus entirely on honoring their family legacy, completely unburdened by institutional court interventions. The systemic loophole is designed to capture the uneducated consumer who assumes a simple notarized signature is an impenetrable shield. It represents a silent wealth transfer friction that continuously drains middle-class resources, rerouting capital directly into administrative systems. To reclaim control, you must execute a scientific environment control skill that alters the very architecture of your asset ownership. This involves transitionally retitling your core bank accounts, real estate, and business ledgers directly into a private trust structure. By doing this, you establish an automated environmental default switch that operates independently of any public clearinghouse or court. During your lifetime, you maintain absolute operational dominion as the trustee, managing your properties exactly as you always have. The moment you pass away, your designated successors step in automatically, bypassing the need for any institutional validation. Do not wait for a structural family crisis to discover the inherent vulnerabilities hidden within a standardized traditional testament. Take definitive action tomorrow morning by consulting a qualified estate planning attorney to audit your current property holdings. Instruct them to establish a robust living trust architecture, formalizing an optimized pathway that guarantees maximum asset preservation velocity. By structurally immunizing your hard-earned assets today, you permanently defend your generational legacy against systemic legal loopholes. Protect your capital, upgrade your financial intelligence network, and subscribe to Economecha now to master the mechanics of true wealth preservation.